Yes, DENNIS here for Mr. Bostry. We're ready.
Ms. Williams, you may proceed.
Thank you, Judge. At this time, the department will request that the following documents be admitted as public record. Exhibit number 1, DIC 23 and incorporated documents, which does include the offense report. Exhibit number 2, the DIC 24. Exhibit number 3, DIC 25. Exhibit number 4, the lab report. And the last exhibit, exhibit number 5, the blood affidavit.
Mr. Dennis, do you have any objection to those exhibits?
We object to DPS Exhibit 1, Judge. I believe it's incomplete. On the discovery log that I received on September 17th, it says DIC 23 and incorporated documents 4 pages. And I got 4 pages. But when I started looking at them, I have page 1 of 4 and I have page 3 of 4. I don't have 2 of 4 or 4 of 4. I have 4 total pages, but it should be, I guess, 6.
Okay, let me pull that up because it looks like we had 2 different exhibits drop. And so the oldest one, okay, one's DIC 23 and incorporated docket says 4. All right, let me scroll down. Okay, I see what you're saying.
Yeah, Judge, I noticed that before that it's missing, looks like 2 pages. So the department would ask for a continuance in order to supplement, Judge.
I don't have an objection, Judge. That's fine.
Okay. Based upon that, so I'm not going to admit any of those exhibits. I will grant the department's motion for continuance unopposed. Is there anything else?
No, ma'am. Nothing from the defense.
All right, then thank you both. That will conclude this hearing.
Thank y'all.
Thank you. You have that's it for you, sir. You have a good day.
Y'all too.
Let me make a note of that. Okay, so I think I had an attorney I didn't have on my docket. I saw pop on. Mr. De Los Santos. Oh no, you are a defendant, and I have you logged in now. Thank you, sir.
Okay, thank you.
Who doesn't have Mr. Ahmed? Would you like to go on Radu Matran?
Yes, Judge.
All right, Miss Williams, are you ready on that one?
I'm ready, Judge.
All right, here we go. This is case number 40524-02569, Texas Department of Public Safety versus Radu, R-A-D-U, Matran, M-A-T-R-A-N. Today is Monday, November 6, 2023, 9:09 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. It is being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, will the parties please announce, beginning with the attorney for the department.
Crystal Williams, W-I-L-L-I-A-M-S for the department. We're ready.
Hassan Ahmad, HMAD for the respondent. Ready.
Okay, go ahead, Ms. Williams.
Thank you, Judge. At this time, the department would ask that the following documents be admitted as public record. Exhibit number 1, DIC 23 and incorporated documents, which does include the offense report. Exhibit number 2, DIC 24. Exhibit number 3, DIC 25. Exhibit number 4, the breath test slip. And exhibit number 5, the DIC 56.
Any objections to those exhibits, Mr. Ahmed?
Judge, on this one, we did get an email because the discovery was not provided on time that the department would be filing a continuance from Crystal Williams. So we would be unopposed.
Okay, just, I might have forgotten to make that note here on a late pre-file. So, looks like it was filed on October 30th, Judge. So the department will move for continuance. I believe this is the first setting, Judge.
Okay, Mr. Ahmed, you indicated you are not opposed to that. Is that correct?
We're those, Your Honor.
Okay, so I will not admit any of those exhibits. I will grant them an unopposed motion for continuance, and if there's nothing else, thank you both. That will conclude this hearing.
Thank you, Judge. Maybe
You may start. Thank you. Bye-bye. Okay, so let me bump down to Mr. Schultz on Robert Shelton, and you indicated, sir, that was a paperwork case.
Yes, ma'am, Your Honor.
All right, and Ms. Williams, are you ready to go on that one?
I am, Judge.
Here we go. This is case number 40523-26253, Texas Department of Public Safety versus Robert, R-O-B-E-R-T, Shelton, S-H-E-L-T-O-N. Today is Monday, November 6, 2023 at 9:12 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. This case is being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, will the parties please announce, beginning with the attorney for the department.
Crystal Williams, W-I-L-L-I-A-M-S for the department. Ready?
Jeff Schultz for defense, S-C-H-U-L-T-Z, and we're ready.
Ms. Williams, you may proceed.
Thank you, Judge. At this time, the department will request that the following documents be admitted as public record. Exhibit number 1, DIC 23. Exhibit number 2, DIC 24. Exhibit number 3, DIC 25. And exhibit number 4, the incident report.
Any objections, sir?
Yes, ma'am, Your Honor. On DPS number 4, I have to object. It seems as if we have a similar issue. The amount of pages that were sent states that there's 4 pages. However, the report lists that there should be 5 pages, and it looks like I'm missing page 2 and 4 of the report.
Okay. And Ms. Williams, if you could take a look at that for me as well, please.
Yes, Judge.
Do you see that in what I have filed?
Yeah, Judge, it appears to be at least 1 page missing. I can't confirm if it's page 2 or if it's page 4. However, yeah. So, go back to this one. The department would ask for a continuance, Judge, to supplement that report.
Objection on that, Mr. Schultz?
Yes, ma'am, Your Honor. I have to object on that. This has already been continued. I'm unable to find the officer. He doesn't work for that facility. In addition, Robert Shelton's blood has come back under the legal limit, and they've already dismissed the criminal case that he had received as a result of this officer's arrest. So I'd ask for the continuance be denied and a dismissal on this ALR case.
Up into my records, and I'll give you an opportunity to respond. I only show 1 continuance, and it was yours, sir, on a 5-day. So based upon that, I would be inclined to grant the department a continuance as well in this matter today. But I will take further arguments if you have any.
Nothing further on that, Your Honor.
Okay, so I'm going to grant that motion for continuance. And if there's nothing else, then that will conclude this hearing. Thank you both.
Your Honor, if I may?
Yeah, go ahead. Sure.
Just in response to the admission of defense exhibits in this case for today's hearing,
Oh, sure, go ahead.
I offer Exhibit A for defense exhibit and Exhibit B for defense exhibit. I've already sent notice to the department. It's the laboratory results from the Department of Public Safety and a dismissal from the county court at law in Montgomery County, Texas.
Yeah, and I'll kind of give you the options, but the way these things work, so if this is getting continued, it may not be me that here's the next one. It may go on another judge's docket. And I think it's cleaner to not admit anything on this setting. I'm not going to admit her stuff, and to wait till the next setting to offer those exhibits. They are in e-court. I do see them. So I think it's procedurally better to wait till the next setting to offer those.
I understand, Your Honor. Yes, ma'am.
But yeah, like I said, they are in e-court. We have them, so that's not a problem. But yeah, let's wait for admission of any exhibits until the next setting. And with that, will conclude this hearing.
Thank you.
All right. Thank you both.
Yes, ma'am. Thank you, Your Honor. Thank you, Ms. Williams. Hope y'all have a
Thank you,
good day.
Ms. Stokes.
Thanks, you too. Bye-bye. Okay, so I got that one. I saw Mr. Pham log on. It is 9:16. Ms. Williams, do you have all the what you need on all of the subpoena returns that I've kind of run through?
I do, Judge, and if I may, I do have one preliminary on one. It's not one concerning an officer. It's a pro se for Christopher Wilson. I did file a written motion to continue. I had reached out to Mr. Wilson via email to see if he was opposed, but I hadn't heard back before I filed the motion. So I'll ask for continuance on that one. And this is the first setting, Judge.
Yeah, I had seen that, and I was and it looks like he's dropped off the call. So yeah, I would grant that because you're correct. It is the first, but let's wait and see if he hops back on the call. But yeah, I since you already filed the motion, I'll grant it and generate a reset. But hopefully we can get him back on the line to make sure we have his correct information for service purposes.
Yes, Judge. Thank you.
All right, you're welcome. Okay. So in no particular order other than the way e-court spit it out, my first one is going to be Miss Negrich on Denver Anderson. That's going to be Officer Cardenas, New Caney SO.
I'm ready, Judge.
I'm also ready, Judge.
Perfect. Here we go. And this is case number 405240244, Texas Department of Public Safety versus Denver, DENVER, Anderson, ANDERSON. Today is Monday, November 6, 2023 at 9:18 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. It is being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, will the parties please announce, beginning with the attorney for the department.
Krista Williams, WILLIAMS for the department. We have a preliminary.
Alexandra Negrich, NEGRICH for the defense.
Go ahead, Ms. Williams.
Thank you, Judge. The department is in possession of a sufficiently served subpoena for an officer Cardenas. In this case, we have not heard from this officer as to why they're not present and available to testify. So at this time, the department will move for dismissal.
No objection, Your Honor.
That is granted. Thank you both. That will conclude this hearing.
Thank you, Judge.
Thank you, Judge.
Thank you. You're welcome, and I'll get that order issued probably today.
Thank you, Judge. May I be excused?
You may. Good to meet you. Have a good one.
You too. Bye-bye.
Thanks. Bye-bye. All right. Let's go to Mr. Santos on Veronica Wareham, Officer Moss Conroe PD.
Yes, Judge, we're ready.
All right. Perfect. And here we go. This is case number 40523-20881, Texas Department of Public Safety versus Veronica, VERONICA, Wareham, WAREHAM. Today is Monday, November 6, 2023, 9:20 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. It's being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, will the parties please announce, beginning with the attorney for the department.
Krista Williams, WILLIAMS for the department. We have a preliminary.
Mario Santos, SANTOS, on behalf of the defense. We're ready, Judge.
Thank you. Ms. Williams, you may proceed.
Thank you, Judge. The department is in possession of a sufficiently served subpoena for an Officer Moss in this case. We have not heard from this officer as to why they're not present and available to testify. So at this time, the department will move for dismissal.
No objection, Your Honor.
That's granted. I'll generate the order. Thank you both. That will conclude this hearing.
Thank you, Judge. May I be excused?
You may. Good to see you. You have a good day, sir.
You too.
Thanks. All right, Mr. Stamba, are you in a position to go ahead and run your
Judge.
case? Perfect. All right. I know. It's
People were calling me, messing me up.
you know, it's, yeah, technology is supposed to make our lives easier, but it seems to just kind of make it more complex sometimes. All right. Okay, Ms. Williams, are you ready on Juan Hernandez with Deputy Coley, Montgomery County?
I am ready, Judge.
All right, perfect. Here we go. This is case number 40523-26589, Texas Department of Public Safety versus Juan, Juan, Hernandez, Hernandez. Today is Monday, November 6, 2023, 9:21 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. It's being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, will the parties please announce, beginning with the attorney for the department?
Crystal Williams, Williams for the department. We have a preliminary.
Frank Stambaugh for the defendant, Stambaughh. We're ready.
Ms. Williams, you may proceed.
Thank you, Judge. The department is in possession of a sufficiently served subpoena for an officer Coley. We have not heard from this officer as to why they're not present and available to testify. So at this time, the department will move for dismissal.
No objections, Your Honor.
That's granted. I'll generate the order. Thank you both. That will conclude this
Thank
hearing.
Have a good day. Bye-bye.
Thanks, sir. You too. Mr. Romaser? Perfect. Keith Porter, Deputy Orem.
I'm ready, Judge.
Perfect. Here we go.
We're ready, Judge.
This is case number 40523-26407, Texas Department of Public Safety versus Keith, Keith, Porter, Porter. Today is Monday, November 6, 2023 at 9:22 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. It's being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, will the parties please announce, beginning with the attorney for the department?
Crystal Williams, Williams for the department. We have a preliminary.
Jeremy Romoser, Romoser, for Mr. Porter.
Okay, go ahead, Ms. Williams.
Thank you, Judge. The department is in possession of a sufficiently served subpoena for a Deputy Orem in this case. We have not heard from this officer or deputy, as to why they're not present and available to testify. So at this time, the department will move for dismissal.
No objection, Your Honor.
That is granted. I'll generate the order. Thank you both. That will conclude this hearing.
Thank you.
Mr. Romoser, I said it wrong. I apologize.
No, that's fine.
I pre-apologize for the next time I see you, and I probably will not remember. So.
Yes, ma'am. Thank you. May I be excused?
You may. It's good to see you. Have a good day, sir.
You as well. Thank you.
All right, Mr. Pham on Carlos Aguilar with Deputy Cox.
Yes, Your Honor.
All right, good morning.
I'm ready on that one, Judge.
All right, perfect. Here we go. This is case number 40523-26170, Texas Department of Public Safety versus Carlos, Carlos, Aguilar, Aguilar. Today is Monday, November 6, 2024 at 9:24 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. It's being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, would the parties please announce, beginning with the attorney for the department?
Crystal Williams, Williams. We have a preliminary.
Michael Pham, picture, you have defense ready, Your Honor.
Okay, go ahead, Ms. Williams.
Thank you, Judge. The department is in possession of a sufficiently served subpoena for Deputy Cox in this case. We have not heard from this deputy as to why they're not present and available to testify. So at this time, the department will move for dismissal.
No objections, Your Honor.
Okay, that's granted. I'll generate the order. Thank you both. That will conclude this hearing.
Thank you.
Thank you, sir. It's good to see you. Have a good day. All right, and I have a gentleman named labeled Brad. Can you let me know what case you're here on, please, sir?
I was here on Israel Carreno. Docket number 405.
Oh, yeah,
291.
I didn't have you down as his attorney. Mr. Carreno is on the call.
I'm not his attorney. I have a subpoena that was sent to me from him to appear.
Okay. Well, that's only licensed attorneys can issue subpoenas. So, Mr. Carreno, do you know what he's talking about?
Yeah, I sent him a subpoena through USPS.
Are you a licensed attorney?
I am not a licensed attorney.
Did you have a licensed attorney do this document?
No.
Okay. Sir, tell me your full name, Mr. Brad.
Brad Crocker, Bradley Crocker, Bradley Crocker.
And are you with a particular agency?
No, I'm just a citizen that was involved in a traffic accident, and I guess Mr. Carreno wanted me to appear as witness to the accident.
Okay.
All I know is I got the subpoena, so.
I'm releasing you from that subpoena. That subpoena has no legal effect at all.
Okay.
Okay. You're welcome to stay because this is a public hearing, but you most certainly do not have any obligation to do so. Okay.
Okay.
So I'll leave it up to you. You can stay in the room or you can leave.
I'm interested in the outcome in this particular case.
Okay, that's fine. Let's pop on the record. All right, Mr. Carreno, we're going to go on the record, but we're going to address this because you can't just issue summonses to court to people, okay? Do you understand that?
I'm listening.
Do you understand it?
Yeah, I'm representing myself, and
Okay,
I just went through the documents that were online.
Well, the documents that are online indicate to you that you cannot issue that yourself. You have to request the judge to issue the subpoenas. So had you read those documents, that's what you would have seen. But you issued legal service on a person without having a law license. That borders on the illegal practice of law. You cannot do that. Do you understand?
I understand.
All right. Let's go on the record on that one. You ready on that, Ms. Williams?
Yes, Judge, I'm ready.
This is case number 40523-20291, Texas Department of Public Safety versus Israel, ISRAEL, Carreno, CARRENO. Today is Monday, November 6, 2023 at 9:28 a.m. My name is Erin Bacher, and I'm the Administrative Law Judge assigned to hear this case. This case is being heard by the State Office of Administrative Hearings via video and telephone conferencing. At this time, will the parties please announce, beginning with the attorney for the department.
Crystal Williams, WILLIAMS for the department. We're ready.
Mr. Carreno,
I'm ready.
please identify yourself.
Israel Sierra Carreño.
We had some discussion before we get on the record. Mr. Carreno, you indicated to me you are representing yourself. Is that correct?
That is correct.
There's a gentleman named Brad Crocker who logged in on the call who's still here, who told the court that you issued a subpoena for his appearance today. Is that correct?
From what you told me, that is correct.
No, sir. You were here when Mr. Crocker told us that, and you told me before we went on the record that you did send him a subpoena via the postal mail.
Yeah, I was
Correct?
trying to follow everything that I could on my end. Correct.
Okay. And what I had indicated to you off the record is you are not a licensed attorney. You cannot issue a subpoena on someone to testify.
Judge, can I ask
Do
you
you
a question?
Yeah, I'm going to give you an opportunity to ask a question, but we're going to go over some stuff first, okay, sir?
I'm following.
There's a couple of things. You indicated to me that you went on the website. Well, the website has information on representing yourself. And what the law says is you have to file a motion with the court to have a subpoena issued, and only a judge can issue that subpoena. And that is not what you did. Is that correct?
I understand. Correct.
There's also rules of evidence that when a subpoena is issued, the other party, the department, is entitled to notice that that subpoena has been issued. It must be served on them and filed with the court. You did not do that either, did you?
I don't know how to follow any of those procedures. Again, I'm representing myself, so yes, I am accepting what you just said.
And I understand, and I want you to be able to represent yourself, but when you serve legal documents on citizens, that's when we walk into more dangerous territory. Do you understand that, sir?
I understand.
Okay. What are your questions?
No, actually, you answered the the things that I needed to understand. Thank you.
So the last hearings we had, July 10th, you asked for a continuance to hire an attorney. September 5th, you were granted a continuance to hire an attorney. And October 5th, you were granted a continuance because you had a conflict with something else going on. So are you ready to proceed today?
Yeah, I'm ready to proceed at this point. I don't really care about the outcome. This can go on the record. Of course, it is on the record.
Okay, well, I don't think you shouldn't care about the outcome.
It's caused a lot of health issues with my mind, and I don't want to really be dealing with this over and over again. I don't have money to pay an attorney because of said situations that happened during the accident. There was no actual traffic stop or anything like that, and everything that was said about me, it just puts me in a very bad predicament. So at this point, it's not that I don't care. I just don't want it to cause any more mental havoc on my mind anymore. Okay, it's been stressing me out, and I can't be going about my day anymore. Right now, I can't even be working. It's too much. At this point, I've accepted the outcome, whether it be good or bad. Since I was young, I tried my best to get my licenses and everything since I was 14, and I've been going everything through the procedures. Hey, inevitably, it just seems like it's school all over again, and at this point, I'm accepting whether things come out good or things come out bad. I'm just going to continue with my life. At the end of the day, I am here on DACA, and this DUI, whatever you guys want to accept it as, is just going to terminate my DACA. And hey, I'm just here.
Let me ask you a few things, because this is the first time I've had this case. Did you receive the pre-file exhibits from DPS prior to today?
Yes, the last judge actually went over it with me, as well as the other DPS representative. And I don't accept any of them, but at this point, when they do become a public record, it's just like, again, I don't want to repeat myself. Okay. You understood what I said last time.
Okay, well, let me make sure a couple of things that we get straight. Okay, so in this hearing, yes, you do have the right to represent yourself. Though this case, these circumstances began with you being arrested for allegedly driving while intoxicated, this matter is completely separate. Do you understand that?
Separate? I'm sorry, what?
Sure. No. So this is a civil case. This is not a criminal case.
Oh, yes. They've explained that to me in the other courtroom.
Gotcha. Okay. So the burden of proof in this case is on the department or DPS, and what they have alleged in the notice of hearing that was sent to you to tell you, yeah, you requested this hearing and it was set, was that there was reasonable suspicion or probable cause to stop or arrest you on the alleged date of May 14th of this year, that there was probable cause to believe that you were operating a motor vehicle in a public place while intoxicated, that you were placed under arrest, and you were requested to submit to the taking of a specimen, and that after being requested to submit to the taking of the specimen, you refused, okay?
I did not refuse.
I see you shaking your head, but we're not to that point yet. Those are the elements that DPS has to prove.
I know.
Okay?
I'm following.
And their burden of proof is by a preponderance of the evidence, okay? So they get to go first to present their evidence. And once they have presented their evidence, then it would be your turn to present any evidence or offer any testimony as you see fit, okay? Do you have any questions before we get started?
No, I just want to continue with this so it can be over with.
Okay. Ms. Williams, you may proceed.
Thank you, Judge. At this time, the department would ask that the following documents be admitted as public record. Exhibit number 1, DIC 23. Exhibit number 2, DIC 24. Exhibit number 3, DIC 25. And exhibit number 4, the incident report.
Mr. Carreno, do you have an objection to those 4 exhibits being admitted into evidence?
The blood record and the incident report.
Say that again?
the blood and the incident reports, whether that be from the officer and as well as Mr. Brad.
Okay, what I'm asking you is, DPS has offered to admit those 4 exhibits as their evidence, meaning I can now look at those 4 exhibits and read what's in them and use them in evidence in deciding if DPS can meet their burden of proof. Do you have an objection to those exhibits being admitted?
I have personal objections, but you can just go ahead and follow it. So I'm going to say no objection. And
okay, let me explain something just a little further.
No,
on that
I understand, but
no, I know, but
go ahead, yeah.
I don't know that you do because I haven't interacted with you yet. I just want you to know that having an objection to evidence is really more of is it what Ms. Williams says it is? Are those in fact those documents? That is the legal foundation to admit evidence. That is different from whether or not you agree what is in those exhibits. Does that make sense?
I understood. That's why I said no objection.
Okay. And DPS 1, 2, 3, and 4 are admitted.
Thank you. The department will rest.
Okay. So by resting, Ms. Williams is indicating the department has no further evidence to admit. At this time, do you wish to offer any evidence or testimony, sir?
Yes.
Okay. Would you like to offer a testimony or a document?
I've sent a few emails to a specific email from where they sent me, the DPS department sent me. The DPS department sent me the proof, whatever you guys call it, and then there was an email at Houston something zone dot at DPS at something, and I've already sent some emails there. I sent the pictures of my vehicle. I can testify on what the pictures are if you guys don't receive the actual documents. Would you be okay or want to listen to my testimony at this time?
You have the right, absolutely, to offer testimony. To do that, I would have to place you under oath.
Yeah.
And then you could give your testimony. Ms. Williams would have an opportunity to cross-examine you. I do have to advise you, though, that if you do give testimony under oath, since this is being recorded, whatever you testify to today can be used against you in another court case, like a DWI trial. Okay? So,
a
just
DWI
need
what?
to make sure. The criminal case. If you're giving testimony under oath today, that could be used against you if you testify in another case, like if there is a criminal case that came along with this, or a civil case with the accident, that basically that you need to understand that by testifying, you are opening yourself up for anything you testify to be used against you in another court. Okay?
I'm aware.
Okay. As far as the pictures, so exhibits have to be filed with the court as well. Proposed exhibits, just like the proposed exhibits that DPS sent you, they sent the court those as well, so I do have those. I do not have any pre-filed exhibits from you. Ms. Williams, do you have anything that you've received?
I do not have any e-filed exhibits, Judge.
Okay. So if they haven't been pre-filed, then the rules say that they can't be admitted at this hearing. Okay, sir? But you absolutely can testify. Mm-hmm. Do you wish to testify?
I do.
Okay, raise your right hand for me. Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, you can lower your hand. You've already stated your full name. You are representing yourself, sir, but you do not have to ask yourself questions. So when you are ready, please proceed with your testimony.
On the night of the accident, and that's how I'm going to refer to as the accident, one day prior to Mother's Day, on the 13th, if I'm not mistaken, I was driving northbound on I-45. That night, another vehicle, a white vehicle, had rear-ended me on my right side bumper. rear right side bumper. The I-45 was wet and slippery. My vehicle slipped. There was a pothole. My tire exploded. I tried to maneuver my vehicle to the left skirt of the I-45 highway, and after the first, that would actually be the second crash, me hitting the left skirt. I lost consciousness after that impact. After that, I can only imagine what happened. So on that end, Mr. Bradley Crocker can try to testify in this case, but I know he should not be talking today. I know he already wrote his testimony for the police report. The police report states something else, very simple. They don't state the first vehicle. I tried to communicate to DOT to see if I could acquire some camera footage. They said they don't save any of that. So the intoxication part, everyone else was saying that I was intoxicated. I understand. And at that point, it's the case where there was alcohol in my system and I hadn't really eaten anything that day. So it's gonna show really high. I've accepted everything and I'm okay with everything at this moment.
Is that the extent of your direct testimony you'd like to offer, sir?
I'd say yes.
Okay. Ms. Williams, do you have cross of Mr. Carreno?
No, Judge, that's from the department.
Okay. Mr. Carreno, would you like to call another witness to testify?
This is...
Okay, let me back up for 1 second. Just because you could not subpoena Mr. Crocker, he is here.
Yeah.
He chose to stay.
I appreciate that, and thank you for showing up, honestly.
So if you want to call him as a witness, you may do so.
Right now?
Yes.
Oh, yeah, please, can you tell me your end of the story?
Hold on.
Oh.
Yeah, let me swear him in, okay?
Yeah, of course, do what you have to do.
Mr. Crocker, will you raise your right hand for me, please? Thank you. Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand, sir, if you would please state your full name for the record.
Yeah, Bradley Crocker, Crocker.
Thank you, sir. Mr. Carreno, you may proceed, and just remember, please, ask him questions, okay? But when you're ready, go ahead.
Oh, honestly, I just want you to tell me if, number one, did you try to evade the accident after you saw that my vehicle had impacted the left skirt?
I did not try to evade any accident. I didn't see an accident before I was hit by something. So, from my recollection, I was just driving in the exit lane on 45 and was hit from behind and didn't see it coming.
Okay. On the police report, it stated that you were merging left, if I'm not mistaken. So did
I was going right. I was getting off the exit at the next exit.
Okay. And did at any point did you decelerate, press on the brake pedal?
I don't think so. I think I was still probably doing 50, 55 miles an hour in the lane. I think I was already in the exit lane and had been for a couple of seconds. And I was just probably wasn't continuing to accelerate, but I wasn't braking at this point either. I've gotten off at this exit, hundreds of times. So it was, I was not hitting the brake to the best of my knowledge.
Got it. Okay, yeah, no, those are the main questions that I had for you on the police report. I'm sure that Judge Aaron may or may not look over it. I'm not so sure who looks over these documents. I know that Crystal Williams, the DPS representative at this moment, does or has checked over the police report. I wanted to amend the police report, Judge Aaron Baker.
I'm sorry. Let me stop you 1 second. Do you have any more questions?
Oh,
of
no,
Mr. Crocker?
Mr. Bradley Crocker,
Okay.
that's it for my questioning.
Okay, thank you. Ms. Williams, do you have any questions for Mr. Crocker?
No questions on cross, Judge.
Okay. So, Mr. Crocker, at this point in time, you are excused. Again, you're welcome to stay. But we appreciate you giving testimony today, sir.
Okay.
Thank you.
Thank you.
Now, Mr. Carreno, so at this point, do you have any more evidence to offer via documents or testimony?
I think I went over the DPS where I sent them an email and they said that they didn't save any of the footage. I tried talking, so this would be a testimony. I tried talking to Officer Parent. He did give me a call, but at that moment when he called me, my mind went blank because I had previously talked to another officer and had given him my statement, and that officer, the previous officer from Officer Parent, had asked me if I wanted to talk to Officer Parent instead because he was the officer assigned to the report. I said yes, but I had already given my testimony to the first officer, and when Officer Parent called me, my mind went blank, mainly because I haven't been able to put a face to the name. At the hospital, everything was kind of dark. It's like there were so many faces coming in and out. So yeah, I wanted to amend the report. I don't know how to do that or what procedures to go through that, so they can actually write my end of the report. But at this moment, that's about it. I don't have anything else to say.
Okay. I don't have jurisdiction over police departments amending reports, but you mentioned, I will be reading these documents. They've been admitted into evidence, so that I will be reading all of them to determine whether or not DPS met its burden of proof. Do you want to give testimony to something that's in those documents that you do not agree with? Because you can do that.
I think I went over everything, like just to rehash the blood records. Oh, one more thing. I didn't. What's that word? When the
I'll stop. The blood is not at issue in your case. What is before me? What DPS has alleged involves you refusing to submit to a blood test.
There was no refusal.
So any blood results are not part of the evidence I would review or would have anything to do with I'm tasked with deciding.
Okay. Judge Aaron Baker, can I say a few more things?
Yes, sir.
So I know it's over the fact that there was no traffic stop, but at the hospital I did not refuse any breathalyzer or blood drawn from me. Officer Parent, I was trying to ask him, he brought in a paper and I asked him if I could read it personally because I was not understanding what he was telling me. Not because I didn't understand the words coming out of his mouth, but at that moment everything was blurry and hazy. I was under anesthetics from the hospital. I was trying to figure out exactly what was going on. Inevitably he got tired and he just said, I'm gonna take whatever you're telling me as a refusal, and walked out of the actual hospital allocated room where I was at. So if that made sense, he just walked out on me, and since I wasn't able to respond properly to him, he took it as a refusal. Again, I did not refuse to give a breathalyzer or a blood test. That's it.
Thank you. Ms. Williams, do you have further questions of Mr. Carreno?
No, Judge.
Okay. So if that's all the evidence to be submitted, at this point, we go to what's known as argument or closing statements. It's each side's opportunity to give a brief statement to me as to how they think I should find in this case. DPS gets to go first, then you may give a closing if you wish, Mr. Carreno, and then DPS gets to give one final closing since they have the burden of proof. Ms. Williams, close.
Yes, Judge. The department would just ask for an affirmative finding based on the evidence submitted.
Okay. Mr. Carreno, generally the department asks for an affirmative finding. That indicates to me they're asking that I find that they did meet their burden of proof as to each of those elements we went over in the beginning, and are asking that I issue an order saying they are authorized to suspend your driver's license. With that, Mr. Carreno, would you like to give a closing statement or argument at this time?
I don't want my license to be suspended. I worked way too hard to get that, especially since I was 14. I worked way too hard. I went from doing the permit at 16, so I learned how to drive on my own since I was 14. At 16, I decided to take classes, and I paid for them myself. At around 16, 18, I was driving with a permit. Of course, I had to have someone with me over 21 with an actual license. Inevitably, I had to get an actual license to work if I wanted to be a driver for a food carrier, the likes of Uber and DoorDash. So I had to get my actual license, but I had the license prior to actually signing up for those services. Inevitably at 21, I moved to actually taking people in my vehicle because I had enough years of experience while driving, and ever since then I have not had an accident and have kept a clean record with them. I understand the situation, and that's pretty much all I have to say now.
All right, sir, thank you. Ms. Williams, do you have a rebuttal close?
No, Judge.
Okay. So at this point, that's going to conclude this hearing. What happens from now, Mr. Carreno, is I will review all of the evidence, and I will issue a written decision. And that written decision will be sent to you via email, just like the order you got telling you the hearing was today, okay?
Okay.
And thanks you, everyone. That will conclude this hearing. Okay, sir, do you have any questions? Any other questions?
No, I actually really want to just thank Bradley, Mr. Crocker, for being here. I know that I didn't follow proper procedures. I was trying to do my best here, and especially you, Judge Aaron Baker, and Crystal Williams from the DPS department for actually showing up, because you guys would. Thank you, all three of you, and I really appreciate this opportunity.
Well, thank you. I appreciate you, your politeness and professionalism today. And hang in there, okay?
Yeah, thank you.
And you are free to go.